Welcome to today's program titled Navigating Conflicts Between Federal Contracts and State Laws, Unique Defenses for Contractors, the seventh session of our Winning Combinations webinar series. All participants are in listen-only mode. However, you are encouraged to submit questions throughout the presentation by using the Q&A box on the right-hand side of your screen. For those interested in obtaining CLE credit, a code will be read later in the presentation. Please write this code down as it will not be repeated and is required for the CLE credit request form. During the presentation, you will also see a slide containing a QR code that can be scanned to access and submit your request for CLE credit. You can also find a link to the request form in the connection details email you recently received. Copies of the program's recording and materials will be distributed to all attendees in the days ahead. At this time, I would like to turn it over to today's presenters. Adam and Joe, you may begin.
Hey, good morning, everyone, and afternoon for those on the East Coast. My name is Joe Velli. I'm a senior associate out of our New York City office and work in our people analytics group, which essentially deals with any data related to your workforces, whether that be applicant data, hired data, transactions data, including terminations and promotions. And we do a variety of things with that data. So we run pay equity analyses. We also assist federal contractors with the development of their affirmative action plans. And pre-EO 14173, that was a big practice with women and minority affirmative action plans, but still dissecting all of the impact from that executive order and how it impacts your overall programs. And in addition to that, what we're here to discuss today, how that could also impact your state affirmative action obligations, which we'll get to later in the webinar. In addition to those practice areas, I also assist clients in reduction in force work. But with that, look forward to having a robust conversation with Adam and hope this is helpful for you today. Adam, over to you.
Thanks, Joe. My name is Adam Lasky. I am a partner in the Seattle office, and I co-chair our National Government Contracts Group, which has been recognized for the past 2 years by Law 360 as the Government Contracts Group of the Year. Our team represents government contractors on a wide range of compliance, transaction, and litigation in the area of government contracts, from contract capture through closeout. The FAR, at least for the moment, until it becomes a very short pamphlet potentially later this year, who knows, is a dense morass of requirements. And our team helps clients understand how to navigate government contract requirements, including how helping clients understand their rights and obligations when a federal contract requirement potentially conflicts with contractors' state or local law obligations. The most commonly, but not exclusive way this comes up is when the federal government issues some sort of urgent policy edict through an executive order that is quickly crafted into a temporary contract clause and added in mass to federal contracts via a class deviation process. A case in point of this was in 2021 with the federal contractor vaccine mandate, which started with an executive order, which quickly led to a class deviation FAR clause to implement that order, which then led to numerous states passing laws that actually were intended to conflict with the federal contract requirements being added on the vaccine mandate. But FAR clauses and executive orders aren't really laws, and thus aren't subject to a typical federal state preemption analysis. So we ended up getting a lot of questions from clients about, does a FAR clause in their contract preempt their requirement to comply with a conflicting state law? And the answer turns out to be a tricky one. And Joe's going to talk about, one of the cases Joe's going to talk about will kind of show how was a particularly tricky one in the vaccine mandate. But the vaccine mandate scenarios present a good learning point for contractors to look at today, as we are now seeing a different presidential administration take very quick executive actions that have or will result in class deviation FAR clauses, which then may present existing conflicts with state law obligations, conflicts with existing state law obligations, or may trigger states to pass policy laws in response that are intended to actually conflict with these new FAR clauses, which will present similar scenarios to what we saw with the vaccine mandate. So today we're going to help you prepare for that. We're going to try to make this a bit of a generic conversation because as everybody knows, you just don't know what's going to happen from day to day in this administration. So rather than talk simply about what's already happened, want to try to set up a good understanding of what your defenses will be in the event things do occur where there's clauses that do conflict with state law obligations. We're going to talk about three particular defenses that federal government contractors have to state law obligations under these scenarios, and under what circumstances these doctrines excuse contractors' noncompliance with state law. So with that, we're going to jump back to Joe for the first one of these.
Yeah, thanks, Adam. So the first immunity we want to discuss is the derivative sovereign immunity. Federal contractor derivative immunity is often also referred to as the Yearsley immunity, which is a legal doctrine that shields federal contractors from liability for actions that are taken while performing duties that are authorized and directed by the federal government. It's essentially designed to protect contractors when they act as agents of the government and are executing work that is deemed necessary for public purposes. So what it does is ensure contractors are not held personally liable for following these government directives as long as the directives are lawful. As stated, the immunities derived from Supreme Court decision Yearsley versus W.A. Ross Construction Company. It's like an 80-year-old precedent, which established that contractors are immune from third-party claims if their actions meet two specific conditions. And as you see here, that those are the government directed the contractor to take the action for which the plaintiff seeks to hold liable, and the government's direction was legally valid, meaning that the federal law authorized, excuse me, the government to issue that directive. Ultimately, this immunity is encouraging private entities to work on behalf of the government without fear of undue litigation, but also provides some accountability that they're still held against if they exceed the authority granted to them by the government. There are limitations, however, to this derivative sovereign immunity. The immunity will not apply if the contractor acted beyond the scope of its authority and deviate from the government's instructions. If the authority itself was not validly conferred by Congress or exceeded the powers granted by federal law, or if the contractor exercised independent discretion in a way that was not mandated by the federal directive. And I think a good example of that is the Riggs versus UCOR case that we have noted here. In that case, it involved an employee that was fired by the employer for refusing to comply with its COVID-19 vaccine policy. The employee then sued the employer under a Tennessee statute that protected the employee from termination due to vaccine refusal.
And just to be clear, that statute was passed in direct reaction to the vaccine mandate contract clause, and intentionally was passed, I think, so to conflict with the your obligations under that clause. Yeah. Sorry, Joe. I just want to make sure.
No, please jump in. Color commentary makes it lively, so that's good. But the company argued that it had derivative immunity as a federal contractor, claiming its vaccine policy was implemented under that government direction. Ultimately, the Sixth Circuit found that UCOR introduced its vaccine mandate in August 2021 before any government directive required it. Then later in October of 2021, the Department of Energy modified its contract with UCOR to mandate vaccinations, but the directive was then invalidated by a federal court. And then similarly, OSHA had a vaccine mandate that was deemed unauthorized by the Supreme Court. So UCOR's claim that its policy complied with general health and safety requirements in its contract were also rejected, as the contract gave UCOR discretion in implementing measures rather than explicitly requiring a vaccine mandate. So that is where they came down with this decision, ultimately rejecting UCOR's defense that it was covered by derivative immunity. And this affirmed the district court's earlier decision. I think a big takeaway here, and Adam and I were talking about this last night, is that when these orders are coming out and what actions employers want to take, it's really important that, I know that we want to be very diligent. We want to determine a strategy and a call for action on how to comply. But taking action right away without proper analysis and assessment will also could potentially, create legal burdens for you that could blow back, similar to what happened here in this UCOR case. So, I think it's important to stay on top of things, but also, being measured in approach and thoughtful in approach is critical as these EOs get challenged and a lot transpires under this administration.
Yeah, there was probably two things that doomed UCOR here in the court's view. And one was, like Joe said, they acted too soon. These requirements, almost when you get an executive order, when an executive order is issued, it almost never immediately, executive orders are directives to the federal government to do things. They're not directives to contractors. And so they become directives to contractors by the federal government agencies actually acting on the executive orders. In one of those ways, and the most common way, is to include a new contract clause in your contract to implement the executive order. And UCOR took the action that it got sued for prior to that clause being added to its contract. And so the important, I think, a lesson, like Joe was saying, is you should, when you know something's coming, prepare for it. But you don't get covered by this doctrine if you take the action before you are legally required to take that action. And most instances, you are not going to be legally required until the clause gets into your contract. The other thing that probably was a bit more out of UCOR's control here was that ultimately the executive order was enjoined. But so then, therefore, the Sixth Circuit said, well, then the government's direction wasn't legally valid. That, I don't know what they could have done about that, because really, it was enjoined after I believe, I'm not sure about this specific for them specifically, but for a lot of contractors, it was only enjoined after the clause was already in their contract. So that presents a bit of a dilemma. But the direction doesn't go. It's not merely a question of, did the government contracting official, were they allowed under the contract to direct you to do that, but also whether whatever they were allowed under the contract to tell you to do was even legal under federal law. And that was kind of the problem on that one. But this is the most flushed out of all the doctrines. It's probably the simplest of all three. Next one, please, Sadie. Okay, so the government contractor defense has been around for quite a long time as well. It basically is a defense where the government has directed the contractor to do the very thing that subjects it to liability under state law. The primary case on this is Boyle from the U.S. Supreme Court in 1998. While some courts have called the government contractor defense a species of derivative immunity, unlike derivative immunity, this defense which is based on the contractor's contractual relationship with the government. The government contractor defense is based on the concept that federal common law preempts application of state tort law in areas of unique federal interests. Originally, this doctrine was limited just to companies making or supplying military equipment or building military equipment, but has since been expanded to non-military equipment and to services by most circuits. I will say most circuits because the Ninth Circuit has probably been the most reluctant to expand it beyond its original production of military equipment. But even some of the courts within the Ninth Circuit, recognizing that most all the other circuits have expanded it, have themselves found ways to get around to distinguish the federal court, their own circuit's precedent, and have tried to expand it even within the Ninth Circuit. This rule is not as uniformly applied across the circuits, and nor is it as simple. And I'll try to mention a few places here where there has been more distinction between the courts. So this is both, you need to first pass a threshold, And then if you pass the threshold, there's a 3-part test. So the threshold is two parts. First, does the contract concern areas of uniquely federal interests? That is not an extremely high burden. But certain things that might not concern uniquely federal interests would be potentially a construction project not on a military facility that is done as a federal contract. There's courts have found that another thing would be a federally funded state construction project would be another thing. But examples of things that are unique, that specifically have been found uniquely federal interest, which may have particular relevance to this administration, is detention of immigrants in removal proceedings. So it is not the biggest bar amongst this test. The second part is part that has been far less uniformly applied across the circuits, and that there's a significant conflict between the application of state law and federal interest at issue. In other words, the contractor cannot at the same time comply with his duties under state law and his duties under the federal contract. Some circuits have also added a second option, which would be or the frustration or there's the state law frustrates a specific objective of federal legislation. It is less common to see things that are in direct conflict, as in you can't comply with both at the same time. But given what might happen under this administration, it wouldn't be surprising to see things that come from states that this administration might argue frustrate specific objectives of federal legislation. An example of this in application, I put a couple of good, what I thought were cases that really do a good job of flushing out this standard really well. The New Hampshire case and the Colorado case that is below. An example of application of this, the Medicall case is a pretty good example. It involved a suit on the contract was to operate an immigration detention center, and there was a law in Colorado on unjust enrichment, and the contract with the federal government basically gave the contractor that guaranteed the contractor would get $1 a day reimbursement for detainees who were participating in a work program. And as a result, the contractor paid the detainees $1 a day. And they sued under Colorado's law of unjust enrichment. And in response to that suit, the contractor tried to assert this defense. And that defense was rejected. And one of the reasons it was rejected was because that there was no requirement in the contract to pay the detainees only $1 a day. It was that the contract would only reimburse the contractor $1 a day. And so because it was not impossible to comply with both, the court found that this defense didn't apply. Then moving down to, if you get past the threshold, you get to this test, which is a bit more simple. Again, this was originally written around manufacturing and production of military equipment, so it was tied to specifications, but now it's been expanded to services contracts, so it's procedures as well. And the bottom line of this, as the Fifth Circuit said in the case I cited there, the Katrina Canal breaches case, at bottom, this 3-part test is stripped to fundamentally, the government made me do it. If you can say the government made me do it, I didn't have a choice, I had to do it that way per my contract, then you would probably meet this test. If not, you probably don't meet the test. So this is not dramatically different than the sovereign derivative immunity test, but is a little bit different than that test. It's not common that a contractor would win on one, but not the other. Then Next slide, please, Sadie. So the last immunity I want to talk about is the least tested of the immunities, but probably, potentially has the most application in this administration, and that is absolute or official immunity. This is an extension of a Supreme Court doctrine called Westfall, which gave absolute immunity to federal officials from state tort liability for acts that were discretionary in nature and that fell within the scope of their official duties. It's been but has since been expanded by some circuits to contractors performing quintessential government functions. It was largely to protect from federal officials and now contractors from being able to perform discretionary government functions without the distraction of debilitating distraction of defending private lawsuits tied to how those discretionary actions were implemented. The difference from other immunities is this has to do more with the nature of the contract rather than whether the contract requires the contractor to actually violate the state law. It's far less tested than any of the other immunities. I don't even think it's been applied in every circuit. But just because it's less tested doesn't mean it's less applicable. So there's essentially a three-part test here. The private contractor must be performing a quintessential government function. And this is under what the current administration seems to want to do is privatize a lot of things that are currently being done traditionally by the government. And if that occurs, that could really expand this doctrine. But even if your contract doesn't as a whole perform a quintessential government function, where this has mostly been applied is when contractors are performing investigative duties concerning fraud, essentially tied to something on their contract. And even if the contract as a whole doesn't cover a quintessential government function, if the action you take as a contractor that causes you to state tort liability is itself a quintessential government function, then that could trigger this doctrine as well. The second factor is that you are gauging conduct as discretionary. Basically, does the federal contract law regulation require the contractor to act in a specific manner, or does it give the contractor to act in have some discretion as conduct? This is the opposite of the derivative immunity element. Some courts in applying this have then said if the contract does give discretion, then the next question is whether the discretion is grounded in social, economic, or political goals. It has to be, according to some courts, but some courts haven't added that factor. And then lastly, and this is probably where that's probably where the test has failed most, is on the discretion factor. And then lastly, the action has to be taken within the outer perimeters of the contractor's official duties. The biggest way you would fail this if you took an action that was excessive, beyond manifestly excessive, or in violation of your contract, at which point it would be outside of what your delegated duties were. Some courts have applied a fourth prong, which is a bit of a balancing test on top of this. But anyways, that is a summary of this. I want to make sure we have some time left for our further discussion. But these are the three defenses to be aware of. So with that, I'll turn it back to Joe. Joe, you're muted.
Thank you. Thanks, Adam. So, since there's been this flurry of executive orders, we first wanted to talk about the immunities that could be applicable, but we have specifically been getting a ton of questions on the interplay between EO 14173 and a lot of your state affirmative action requirements. And so we just want to take a few minutes here to really discuss what is the current climate and what are we hearing from the state regulators? What are they saying about this executive order, understanding that a lot of federal contractors are uneasy with one, complying with the EO and the certification requirement to not discriminate and run afoul of any anti-discrimination laws or engage in illegal DEI. How does that impact your state affirmative action requirements? What I want to first say is this is an analysis where you should be engaging your legal counsel, whether that's in-house, whether that's externally. You need to make sure that they are part of this conversation, and your procurement team needs to be there, and you need to get a real sense of what is the scope of our state contract and what are the requirements under the what are the contract compliance obligations that we are agreeing to before either providing a supply or service, a good to a particular jurisdiction. And for those of you that are very engaged in that conversation, you'll see that these requirements are not a one-size-fits-all approach. So we have certain states that are very similar to what OFCCP previously required. They would they require utilization analysis, goal setting, your last 3 to 4 years sometimes of transactions data history. Some require this on an annual basis, other require it every 4 years or 3 years. So you really need to get a good sense of understanding what each particular jurisdiction requires, because you're not going to be able to take a uniform approach in many of these circumstances. The other thing I would add is you want to be careful with certain words in these statutes. Now, the state regulators are telling us, we understand what the EO says. We do not believe that our affirmative action programs at the state level run afoul of any federal anti-discrimination laws. So, number one, they're separate and apart from any federal obligation. Number two, even if they were in scope, we don't believe that we are engaging in any type of discriminatory action when it comes to selections of employees. And Minnesota is one jurisdiction that has come out and said that to us from the start. And they said, we're not releasing any additional guidance. What you'll notice with Minnesota is that they said, if you received a workforce certificate by utilizing a prior OFCCP, Women and Minorities Affirmative Action Plan, you have to now resubmit according to Minnesota's state requirements. What is interesting, though, is that they recently released an EEO policy template that scrubbed any reference to affirmative action. They're now calling it a compliance program. So we might start seeing that across the states. But the messaging that we are getting is that these are separate and apart obligations tied to our anti-discrimination laws and statutes, and also our human rights laws within the state. And thus, until there's any change there or the federal government comes after these state level requirements, we will continue to operate as we have in the past, and anyone that wishes to do business with the state will have to continue to comply with these reporting obligations. What I do want to mention is that there is the way Wisconsin's obligations are written. This one does seem to, I think, increase legal risk with how they run their affirmative action program. And the reason I say that is when talking about underutilization, they say that state contractors have to work towards a balanced workforce. And in doing so, they want you to set a reasonable time frame in which you will achieve that balanced workforce. That I would certainly push back on if I were submitting. And the reason being is that can, I think, just be, I think it's overly broad. I think that working towards aspirational goals and engaging in outreach is one thing, but trying to achieve that balanced workforce in light of the executive order, that needs to be a larger conversation with the Wisconsin regulator, and ensuring that we're both complying with the EO and not opening ourselves up to additional risk.
Joe, I'm going to cut you off here because we're running out of time here. We're almost out of time. So I just want to cover a few things real quick before we get,
sure
okay. I just want to make very clear to people that, like, as it comes to these defenses, until there's an actual conflict between your state law requirement, which is, as Joe was explaining, predominantly, if not exclusively right now, only apply to your state law contracts, And the federal requirement, which so far has only removed requirements, it hasn't added any new requirements, very unlikely that you have any of these defenses. However, if the federal government expands what they're doing to say you cannot have affirmative action programs, you can't do these affirmative action programs company-wide, then you now have a state law conflict with federal conflict. Or if the states change their laws and say, if you're a state contractor, you have to apply these affirmative action programs company-wide, including on your federal contractors, then you may have a conflict as well. That's when these defenses come about. But until then, it's very unlikely that you have a defense at this stage. But if things happen like the vaccine stage, then we're likely that we are going to have, if states react the same way they did to the vaccine mandates, then it wouldn't be surprising if we end up in that state again with these affirmative action related executive orders and state law.
For those that called in, I just want to get you the CLE code. It is SS3806. That's SS3806. And for those that are on the webinar, you can scan this code, the barcode here, and do an online submission for CLE credit.
Thank you very much.
Thanks, everyone.